PhD.
Wait. It's the wrong person. It's Hanna, what it should be. I know we are all Eastern European names.
No, we'll just pin them. So currently, because Hannah's the host, that's why they can see, but we have both of them over here.
Okay.
And who do you want me to pin?
Pin her, yes.
She's been pinned.
Excellent. Perfect. Thank you so much. Hello? I see people are still coming in, but I thought that out of respect for our speaker and the broader audience, we're going to start now. Welcome, everyone. My name is Agnieszka Kubal, and I'm Associate Professor in Social Legal Studies at a sister institute to Bonavero, Institute of Human Rights, the Center for Social Legal Studies, just across the corner from here, actually. And I would like to first give the floor to the director of the Bonavero Institute of Human Rights, Professor Rachel Murray, who is very generously hosting today's event. Thank you.
Good afternoon, everybody. You're all very welcome here to the Bonavero Institute. As Agnieszka just introduced me, I am still, I think I can say, starting in October, new director of the Bonavero Institute, and we're really delighted to host this event led by the Centre for Socio-Legal Studies, looking at the special tribunal that's been established for crimes of aggression against Ukraine. And this is extremely timely, politically relevant, and I can't think of a more eminent panel of speakers who will be introduced to you shortly. And the issues that are going to be covered this afternoon are broad and far-reaching around defining aggression, the regional and international dimensions of the establishment, the tribunal, immunities, in absentia trials, and considerations of how to hear from victims, how you define who a victim is, and what are the appropriate reparations for repairing harm suffered, and the latter is an issue very close to my heart. So you're very welcome, and I will now hand you over to Dr. Kubal, for who'll be chairing this session. Thank you.
Thank you so much, Rachel, and thank you again for your amazing, generous hospitality. Russia's full-scale invasion of Ukraine in February 22 unleashed not only devastating violence, but also led to profound reckoning, historical, moral, and political, about how the international community responds to this aggression in the heart of Europe. The years since have seen an extraordinary mobilization of legal ingenuity and institutional will, from prosecutions before the ICC and domestic courts to the documentation of war crimes by civil society and international bodies, to the landmark decision from just last year, 25th of June 2025, by the Council of Europe and Ukrainian government to establish the special tribunal for the crimes of aggression. Subject to securing the necessary political backing and budget, the tribunal is set to become operational in the course of this year. A milestone, but one that raises as many questions as it potentially wants to answer, about jurisdiction, about legitimacy, about protection of victims, and whether legal mechanisms alone can deliver justice in wartime. So this afternoon, we gather not only to discuss the tribunal, but also to ask broader questions about the shape of accountability itself, whom it serves, what it demands of states and institutions, and where legal innovation meets the limits of political will. It is my absolute pleasure to introduce today's speakers of the panel, which opens a broader two-day conference on mobilizing human rights during the wartime in Ukraine. So aside from today's event, we also have two panels tomorrow at the Green Templeton College, which will bring together not only human rights lawyers, but also journalists who, in view of the Ukrainian state being engaged in national security concerns, stepped up together with civil society to document the crime of aggression and document the war crimes. So this evening's panel is kicking off the conference, and it is my absolute pleasure to introduce to you Dr. Mykola Gnatovskyy, who is the Ukrainian judge at the European Court of Human Rights, Dr. Tsvetelina van Benthem, who is a lecturer in public international law at University of Reading and University of Oxford, but she also works as a legal advisor to the Reckoning Project, which is a collaboration exactly between the journalists and lawyers in collecting testimonies from war victims in Ukraine. I have also the utmost pleasure to introduce Professor Adam Bodnar, who is a Polish lawyer, academic, educator. He was a former ombudsman, as well as former Minister of Justice between 2023 and 2025. And joining us online, we mustn't forget, Adam joked with me ahead of the event, well, you're almost German, you organized this event 9 months in advance. But if this 9 months organization taught me anything, is the humility. Is the humility that we are trying to bring here to Oxford, human rights activists, legal professionals from a country that is at war, who every day deal with thousands of different priorities than my humble academic life here. Hence, I am therefore even more grateful to Marharyta Sokorenko, who is the government agent of Ukraine before the European Court of Human Rights, who is joining us online from Kyiv at the moment. And at 5 p.m., we will have also online Oleksandra Matviichuk, the Nobel Peace Prize laureate, who unfortunately had a last-minute clash, and she is currently in Netherlands speaking to a parliament. And again, I think political will and rallying behind political will quite often takes precedence over our academic discussion. This is part of the humility that I wanted to talk about. Nevertheless, I am super grateful to her for finding time amidst her very busy schedule to join us slightly later. So the purpose of this panel is to ask our guests a number of questions about broader accountability around the Russian war of aggression against Ukraine. And I thought I will now move from the lantern and take my more comfortable position among the panel and kick off the discussion. I said already many times today that we are in an academic environment, and we academics, we like to start by defining things. So how about I will kick off with the first set of questions about, to explain to the audience what is so unique about what we are discussing today. What is the crime of all crimes? By that we mean the crime of aggression. So to start with Dr. Gnatovskyy, Judge Gnatovskyy, we often hear about war crimes, but this tribunal is specifically for the crime of aggression. In simple terms, how is the crime of deciding to start a war different from the crimes committed during the war? And why is it sometimes called the supreme international crime?
Thank you very much, Agnieszka. I hope you can hear me. I understand that you can. Wonderful. First and foremost, my heartfelt thanks for organizing this today event, for the invitation, and for the pleasure of being in such a company, in such a place. That's really incredible. And unlike my colleagues from Ukraine, I work now in Strasbourg at the European Court of Human Rights, so it's much easier for me to travel. Strasbourg is not the easiest place to reach by any means, but it's nothing compared to the travel that my colleagues from Ukraine must endure to reach, let's say, Oxford. And I'm particularly happy to be in England and discuss this matter in England, because essentially the idea of the special tribunal was conceived in England somehow, because it starts, and surely we will come to that in our discussion, with a proposal made by Philip Sands in his short op-ed in Financial Times on the 28th of February 2022. And I was extremely privileged to quickly join this project. Philip shared his op-ed with me basically the day it was published. And we very quickly set up the initial group of academics who developed the proposal. And then we presented it at Chatham House on the 4th of March 22. So this is how it started. And it's a pleasure to discuss this with you here, and to understand that even though more than 4 years later the war is still raging, this proposal has turned into something real. And the creation of the tribunal, and again we will discuss it today, is, I would say, well underway, even though one might have wished for slightly better pace, but it's still quite on track, I would say. And now, Agnieszka, to your question. I am personally not convinced that it makes much sense to organize a competition between the supreme international crimes and to start discussing which one is worse. There's a very well-known statement, an idea, that it's actually genocide which is the crime of crimes, and this is how one of the most influential books on the subject in the academia, published over the last 30 years, is called. But it's also true that the definition that you gave was already part of the discourse around the Nuremberg Tribunal. And it's also curious that those who insisted on including the crime, as it was called at the time, crimes against peace, to Article 6 of the Nuremberg Charter, were representatives of the Soviet Union. And it is ironic, and it also shows that from the outset there was always this undertone of lack of sincerity, I would say, in this. Because it is the Soviet Union that, together with the Nazi Germany, started the Second World War by occupying Poland in a joint enterprise to divide Europe. And it was not before Nazi Germany decided to attack the Soviet Union that they found themselves on the different sides. And then the Soviet Union, out of necessity, had to beg for help the United Kingdom and the United States, which they actually provided. And as we know, luckily for us, the United Nations won the war. But there was still, even though that crime was already in the Nuremberg trial, there was no discussion about holding the Soviet Union responsible for that crime, which was, I think we must insist on this. And it's more comfortable for me to do as a Ukrainian than for my Polish friends. But I think we must insist that they were complicit in that crime. Now, of course, there is also rational reason for calling the crime of aggression sort of the mother of international crimes. because the large-scale use of force by one state against another state creates the environment in which other supreme international crimes, the atrocity crimes, take place. It creates a perfect environment for war crimes, but also for crimes against humanity, and also for the crime of genocide. Crimes against humanity and the crime of genocide, formally speaking, do not require the context of an armed conflict. So they can be committed outside of this, as the lawyers gathered here know perfectly well. However, the existence of the armed conflict, the existence of mass violence, greatly contributes to the commission of such crimes. That's why it makes perfect sense, actually, to go after those who are responsible for the crime of aggression. Obviously, we will discuss the difficulties that surround this, this idea, this enterprise, because surely states, even after having prohibited in very unequivocal terms the unlawful use of force, in the Paris Pact in 1928 and in the United Nations Charter in 1945, they still wanted to leave certain room for maneuver, to take certain liberties with the prohibition of the use of force. And they did so, and that's why they opposed the most powerful states, the states that actually had the capacity to use force against other states, or at least threat of force against other states. They were never enthusiastic about a clear institutional framework for prosecuting the crime of aggression, or even for establishing the crime of aggression. And again, without trying to establish the hierarchy between the different crimes, what we had on the 24th of February 2022 was a permanent international criminal court vested with jurisdiction over war crimes, crimes against humanity, and the crime of genocide, provided, of course, that it was about the states parties or citizens of states parties, or there was a sanction of the UN Security Council, but still that existed, and that does exist. And as we can see from the activities of the ICC, they are prosecuting war crimes and crimes against humanity in the context of the war of Russia against Ukraine. However, there was nothing that could allow the ICC, even in theory, to deal with the crime of aggression. And that was the product of the deliberate reticence, deliberate reluctance of the major players to actually vest the ICC with that kind of jurisdiction. That's why the proposal, and that's why the crime is so important. However, what needs to be understood also is that the normative prohibition is very clear. What is lacking is the institution. What is lacking is the actual mechanism to ensure accountability. Hence the proposal for the tribunal.
Thank you so much. Thank you so much, Judge Gnatovskyy. You've also mentioned that at the time of Russia's aggression, the International Criminal Court, the ICC, is already, and since then was a permanent court, and is already investigating atrocities in Ukraine. That is my question to Marharyta Sokorenko. Sorry, Marharyta? Excellent.
Hello.
So the International Criminal Court is already investigating atrocities in Ukraine. Why can't it simply handle the crime of aggression as well? What is the specific legal gap that we are trying to fill with the new tribunal?
Thank you for this question, and hello everyone from Ukrainian capital, from Kyiv. First of all, I would like to begin with my thanking to organizers for their outstanding efforts to bring such distinguished experts together, and for a possibility for me to join online to this event. And I am truly honored to be the part of this panel and to share it with such distinguished experts. Turning to the question, we need to start with that the ICC is doing quite important work for Ukraine, and we know that it has issued the arrest warrants. It is gathering evidence, and it has demonstrated that international justice is not merely aspirational. But as you mentioned, and also Judge Gnatovskyy indicated, the ICC has a quite structural limitation when it comes to the crime of aggression. And this is the matter of the treaty architecture. We know that according to the amendments to the Rome Statute, the ICC can only exercise jurisdiction over the crime of aggression when both the aggressor state and the victim state are parties to those amendments. We know that the Russian Federation is not a party to the Rome Statute at all. Ukraine accepted the court jurisdiction, but we cannot trigger the jurisdiction of this court over aggression against the non-party aggressor. And this gap, we have this gap, and this gap was built into system deliberately as a compromise, and it is precisely the gap that leaves the architects of the war legally unreachable by the existing institutional framework. I want the point, the thought I wanted to share, that what makes this particular acute in the crime of aggression, that it is the precondition for anything else. And Ukraine knows that is from its experience, for example, before the European Court of Human Rights. Last year, we have several litigations, several interstate cases before the European Court of Human Rights from 2014. And for example, last year, the court the Grand Chamber delivered judgment in Ukraine and the Netherlands versus Russia case, and it related to the human rights, to the massive human rights violations from 2014 on the occupied regions of Ukraine, in eastern Ukraine, and during the full-scale invasion. This judgment documented in extraordinary detail the systematic nature of what Russia was doing, the list of human rights violations as extrajudicial killings, enforced disappearance, tortures of detainees, etc. And but while the ECtHR powerfully documented those human rights violations, this court doesn't work with the crime of aggression. But all those human rights, they are violations, they are result of this Russian crime of aggression. And all those human rights violations already documented by the Strasbourg court. This is during this aggression and during the occupation is also the result of the Russian aggression. And this is exactly this part, like we cannot bring responsibility to the Russian Federation before the ECtHR because of this legal gap in the treaty architecture. We do not have this possibility to bring this crime before for example, the Strasbourg court, and this is exactly this gap. The intention is to cover this gap by creation this special tribunal. Thank you.
Thank you so much, Marharyta, and I'm also very grateful for Judge Gnatovskyy for bringing us the broader historical perspective of positioning of the crime of aggression, and then to Marharyta for showing, let's say, the institutional gap for that tribunal on the crime of aggression to fill in. So now moving to a question on political will, and this is my question to Professor Adam Bodnar. Poland was one of the first countries to support this initiative. Why is it important for the international community to label invasion itself as a crime rather than just focus on individual acts of violence?
Ladies and gentlemen, yeah? Okay.
No, it's not working. Can I have Fritz green? It should work.
Oh, there's no battery.
It doesn't work.
Okay.
It doesn't work. Can we have another one?
Okay, so maybe...
We can have mine. Have mine in the meantime.
Okay, okay. Fantastic. Great. Okay. Okay. Okay, ladies and gentlemen, thank you very much for the invitation. Thank you, Agnieszka, for making it happen. And I'm really privileged to be here because I spent some time in my role as the Minister of Justice on those issues, trying to support the Polish government in this effort leading towards the creation of the Special Tribunal for the Crime of Aggression. But also I was lucky enough, under the Polish system, Minister of Justice, at the same time Prosecutor General. So I had a chance also to supervise the group of Polish prosecutors that were participating in investigation of crimes, and they were in a good contact with Andrzej Kostin, the then Prosecutor General of Ukraine. They also made some field visits to Ukraine in terms of documentation of war crimes. So I mention this because, in my opinion, we should not forget that it is not just a question of diplomatic or political cooperation between countries. It is also a question of very intensive cooperation regarding the documentation of war crimes, including and other crimes, as well as the crime of aggression, in the context of the preparation for the future, but also in the context of the current proceedings before the ICC. And Poland, you know, which is quite natural, was always present in this discussion, along with along with Baltic states, with countries mostly from Central and Eastern Europe, but also in connection with the Netherlands. And I would like just to tell you one thing. When I was Minister of Justice, we were holding the presidency in the Council of the European Union. And during each meeting of the justice ministers, we organized a session devoted to this issue, to discuss not only the accountability, but also the sanction regime, the question of documentation, and so on and so on. But it was quite interesting to me that when you have that kind of a session, you have, like, you know, different ministers may raise their hand and speak. And it was always Poland, of course, Baltic states, Finland, Netherlands, Romania, Bulgaria, Czech Republic, Slovakia, Slovenia, and that's it. Maybe sometimes Germany, sometimes France, but you could feel that the topic, which is very much present in Central Europe, was not that much present in the mindset and in, let's say, the political argumentation of justice ministers from let's say, Western EU member states. But it does not mean that they did not support the effort towards creation the special tribunal for the crime of aggression. I think, you know, I can only add that that for sure a creation of this tribunal is putting this missing puzzle in this architecture of accountability. But I think still, I remember the session, I organized one session devoted to this during the literary festival organized by Olga Tokarczuk. We invited one guy from the Office of the Prosecutor General of Ukraine, and we tried to explain it in a very simple terms, what are we talking about. Basically, if you have a, let's say, typical war crime, at the end of the day, you may end up with prosecuting one colonel, one general, one military officer that was responsible for doing this. Moreover, if you calculate all different types of war crimes that happen in Ukraine already, you know, depending how you look at this, you know, but some people say that it might be even 150,000 of war crimes that have been committed. So at the end of the day, you will be very much selective, and some people may go unpunished because it is almost impossible to prosecute everybody, to document every case. It is also impossible for sure for the ICC to do those cases. Even the ICC would be selective regarding those cases that are in the jurisdiction. Of course, Ukrainian courts may do a great work in terms of accountability effort. Of course, some individual cases might be subject of universal jurisdiction in different other states. But at the end of the day, you ask the question, okay, but what about those guys who designed everything? What about president? What about Minister of Foreign Affairs, Minister of Defense? What about major generals? And what about authors of propaganda that were contributing to steering the war and to starting the aggression towards Ukraine? And that is why you need accountability for this, because you cannot end up with prosecuting just some individual leaders. You must have like this very much comprehensive view on the thing, because the aggression is a crime in itself, but as Judge Gnatovskyy said, it also creates an environment for committing number of other war crimes, crimes against humanity, or the genocide. So I would like for us also to think about it this way, that it is the only possibility to get justice properly done with respect to those who are orchestrating the aggression towards Ukraine.
Thank you so very much, Professor Bodnar. That really leads nicely your focus on those who instigated it in a high political position to my question to Tsvetelina, who works on indoctrination. Or some of her work within the public international law is that on indoctrination. So what is the relationship between indoctrination and aggression, and how is Russia using indoctrination to fuel its aggressive war against Ukraine?
Thank you so much, Agnieszka, and good afternoon to all of you. Thank you so much to the organizer for this really important and fantastic event. You can't hear me well? Can you hear me better now?
Yes.
Good. Okay. Conquers technology. So I would like to start with the point that Judge Gnatovskyy made, which was about the coercive environment which is left through aggression, which provides a fertile ground for the commission of other international crimes and violations of international law, and the relationship between indoctrination, which is facilitated through aggression, which then links back to the aggression by fueling it and providing more reasons for individuals to join the Russian war effort. And I'm interested in the concept of indoctrination both in my academic capacity, in my capacity as a practitioner working for the Reckoning Project. Why? Because we have seen in the past years that indoctrination, and especially indoctrination with a focus on the militarization of Ukrainian children, has been at the forefront of Russian strategy in this war. Now, by indoctrination, I mean a process of teaching coercively a set of beliefs to individuals or to groups of persons in ways that are reducing the ability for critical thinking or actively discouraging it. And what we see is that in relation to Ukraine, Russia has deployed a wide-ranging and systematic strategy of indoctrinating Ukrainian youth, in many ways grooming Ukrainians, brainwashing Ukrainians, training Ukrainians such that they would create a new generation of soldiers for Russia, a new generation of persons who will be waging that war of aggression, and that will essentially be fighting their own country, who will be fighting their own people. And what we see from the testimonies that we have collected at the Reckoning Project, that Russia is taking advantage of the vulnerability that they're themselves creating. So very often these children are themselves displaced. They're taken away from their families and from their communities. They're subjected to psychological and physical ill treatment. They might have suffered from conduct of hostilities, the bombing of their homes, the killing of their loved ones, the destruction of essential services. And it is precisely in that context of vulnerability that Russia is exploiting them to then indoctrinate and militarize. And what comes through more than 150 testimonies that we have on record at the Reckoning Project is that there is very much a militarization playbook as to how this is done. And this is done very often in schools or through youth organizations or camp structures, whereby children are being taught the Russian language. Ukrainian language and symbols are destroyed or they're displaced. They are singing songs which relate to Russia. They're looking at the flag. They're looking at different symbols. History is being rewritten. And there is a very strong focus on military grandeur. They have visits from military personnel. They're trained to fight. And in many ways, what comes through this entire process is that serving and preserving Russia is seen as one of the biggest virtues and one of the biggest sacrifices that they can make. So what we wanted to do at the Reckoning Project is to ensure that this indoctrination is not seen as something that happens in a law-free zone. That is to say, we're trying to find the legal avenues for accountability in relation to indoctrination. And here we can think of accountability for individuals, but also accountability for the state that is engaging in this policy. We can think of the right to freedom of thought. We can think of the right to education, the right to identity of children, the right to private life. So human rights provides a very good lens to think of these types of policies, precisely because they anchor this human harm. But in addition to that harm, we can also think of the harm which is being done to the Ukrainian people as a people. And the right to self-determination is also a very relevant right to consider in this regard. We can also think of the prohibition of intervention between states, because this is eroding the capacity of the Ukrainian state for self-governance, so it is a coercive interference in their own internal affairs. So in short, this is to say that indoctrination is something which is not only facilitated by this conflict, but it's also something that is fueling further conflict, which is why there must be a lot of focus on those who are responsible for the policy of indoctrination, those who are actually operationalizing it, and the entire environment which is facilitating the indoctrination of Ukrainian children.
Thank you so much. Thank you so much, Tsvetelina, for casting this very important perspective on the crime of aggression. I now would like to start the second round of questions to the panel around something that Adam alluded to, especially around those in holding important public offices who made the decisions. So I want to focus now on what Philip Sands famously warned, in his thinking behind the tribunal, not to let the main man off the hook, and particularly thinking about the agency of Vladimir Putin, the Prime Minister Mikhail Mishustin, and the Minister of Foreign Affairs Sergei Lavrov. The court has opted for a novel approach to long-standing customary law by noting that the heads of state are not functionally immune from prosecution. But, and this is my question to Judge Gnatovskyy, in your expertise, in your capacity as the judge, how this new tribunal will ensure that the senior leaders who planned the invasion are the ones ultimately in the dock?
Thank you. I think we found a good way to Tsvetelina to manage the technology. So thank you very much for this question. I think I think that the question of, well, there's two parts to this question. The first part is holding the leaders accountable, and the second part is, I think, the implied part is about the immunity. He also mentioned the functional immunity. Well, for the first part, the crime of aggression is, by definition, the so-called leadership crime. It's a leadership crime in the sense that only those people who took the decision to wage the war of aggression or to proceed with the war of aggression, and who were directly participating in taking that decision, by virtue of their formal position or even by virtue of their informal position, both options are possible, that they should be held accountable, and not anyone else, to be honest. That wasn't very clear in the Nuremberg definition of crimes against peace, but there was no need for clarity at that point, because the people who were in the dock in Nuremberg were already the top officials of the Nazi state. They were handpicked, manually, politically selected, pre-selected. And then, of course, there was no need to specify that. But for the purposes of enshrining the crime of aggression in the Rome Statute, in the Kampala amendments to the Rome Statute, the definition that we can see now in Article 8 bis of the Rome Statute makes it very clear it's a leadership crime. So this is the first part. Therefore, the very idea to prosecute the crime of aggression means that the leaders are targeted. It is the leaders who are targeted. As a side note, in Ukraine, since 2014, because let us not forget, the international armed conflict between Russia and Ukraine started in late February 2014 with the occupation of Crimea and also the start of armed conflict in the eastern regions of Ukraine. So since then, Ukrainian courts had also to define the scope of application of the crime of aggression as it is envisaged in the Ukrainian criminal code, in whatever, Article 437. And from the criminal code, it was not very clear how far this crime goes. Is it only the top levels, or indeed even officers or lay soldiers, as long as they participate in the war of aggression, can be held accountable? And it took the Ukrainian courts a long time to finally come to the conclusion, and it was the conclusion reached by the Supreme Court of Ukraine, that it should be the leaders. So it should really be limited to rather high echelons of the state power. Even though the controversy is still there, but I think as a matter of domestic law, this has been largely settled in Ukraine through the decision of the Supreme Court. Now, back to the international level. As long as you're targeting the supreme leaders, the question of immunities kicks in immediately. And therefore, again, the question. Let's start with the historical perspective, because it's not such an ancient history after all. So, at Nuremberg, the approach was that of irrelevance of official status of the person for the purposes of the prosecution. And that is also part of the so-called Nuremberg principles that were distilled from the statute and the judgment of the Nuremberg Tribunal, and then endorsed by the General Assembly of the United Nations. So for international crimes, for core international crimes, there should be no possibility to rely on the official position. That being said, of course, the question of immunities remains highly controversial. It is still on the agenda of the United Nations International Law Commission. By the way, as a side note, the UK member of the ILC, Oxford Professor Dapo Akande, was in the initial group proposing the tribunal. So Philippe asked him to join us basically in the first days, and he was very positive and responsive. They are working on the subject. It's highly controversial. The question, especially of personal immunities, of the so-called troika, the three leaders of the state that, according to general international law, can represent the state. They embody the state. They represent the state without any additional need for any additional full powers. That is the head of state, head of government, and minister for foreign affairs. That is still very much under discussion. And again, there are different approaches to the matter. It's not, well, I'll be careful also, even though I enjoy quite a bit of freedom of speech, because I'm not discussing case law or judgments or pending cases at the European Court of Human Rights where I work, but still I have to be mindful of certain limitations. And I can only say that this is not a very straightforward thing. On the one hand, we have the Rome Statute. We have Article 27 of the Rome Statute that says, that basically repeats the Nuremberg approach, irrelevance of official position. Then we have also views that, well, for that, the prosecution should be happening on behalf of the international community. And that, I think, is also something to discuss today, to which extent this effort represents international community. But then, what forum, what court can claim that they are acting on behalf of the international community? Can the ICC do so? Well, the ambition of the ICC to be the World Criminal Court. In reality, the ICC has 125 states parties to the statute, which represents, if we take simply one vote, one state, well, it's 2/3 of the international community. But it's not, the entire international community. And those who are against the ICC, they would not miss the chance to mention that the countries with the highest number of population are all against the ICC, or at least they are not joining the ICC. No China, no India, no United States of America, no Russia, and so on. And you continue the list. Basically, you look at the list of the most populated countries in the world, and you see, it's an irrelevant argument from the point of view of international law, but it's good for rhetoric. It's good as a populist argument. It works very well, and there is also certain relevance because these are important states. These are powerful states. But still, we say ICC represents the international community, so they act on behalf of the international community, hence no immunity. For other crimes, for other tribunals, then it's pretty much an open question. And even with the ICC, there's a big discussion, and it is not a, I'd love to see that this is a settled issue. But let's be honest, it isn't a settled issue, to which extent the ICC can prosecute heads of states which are not parties to the Rome Statute. Yes, there is an arrest warrant against Putin, there is an arrest warrant against Netanyahu, but their validity is a question that I think is not so obvious from the point of view of some states. Of course, this is what the ICC has decided so far, but one can predict that the Assembly of the States Parties will have an entertaining discussion on the subject. Now, as regards other fora, other courts, there it's not a very black and white issue. I would be relying mostly, and I think it's a positive example, on the experience of the Special Court for Sierra Leone, in the case of the former president of Liberia, Charles Taylor. And there I think the solution, basically, they ruled against the immunity, and Taylor was prosecuted, he was tried, he was sentenced, he's serving his sentence here in the United Kingdom, by the way. And I think that's the optimal solution. But to which extent that would have been possible for the Special Tribunal for the crime of aggression against Ukraine? That was an open question, and it was all decided in the negotiations, and I was not part of those, as I assumed my judicial office shortly afterwards in summer 22. So it's obvious from the documents that we can read now that it was a very tough issue, and again, the position of the key states members of G7, other important players, was rather conservative and cautious. Therefore, we have the result that we have, and it's not the worst result in my view. I think it's a tenable result, and it's overall not a bad thing. But of course, the issue of immunities was looming, over the whole project from the very outset. That was obvious even in the most initial discussions.
Thank you so very much, Judge Gnatovskyy, for again bringing this very comprehensive historical and comparative perspective. My next question would be to Marharyta, who is so patiently joining us on the screen. Following from what the judge has said, from Ukraine's perspective, is the challenge proving that the crime of aggression happened, or is it the more practical problem of actually getting the defendants or getting the troika into a courtroom?
Thank you for this question. Regarding the evidentiary question, proving that the crime of aggression occurred, on my point of view, there will be challenges, but I would say, from my perspective, that we are in a stronger position than people sometimes assume regarding in this regard. We have already the substantial record. For example, different public statements, presidential decrees, the security of the Russian Federation, the Security Council debates in the days before the invasion, before the 24th February 2022, and we have also the documented chain of command, and all this it's already have documented evidentiary basis for the process. We also have the results of our first of all, domestic investigations in this regard. But it's also important to highlight that, and it's critically that the evidentiary record is not only what we have from the February 2022. We need to remember that the Russian aggression started from 2014. And this is what Ukraine has been building before the other international judicial bodies, and as I mentioned, also before the European Court of Human Rights. Those cases, they are covering all the events from 2014, covering the annexation of Crimea, the war in eastern Ukraine and the occupation, and those proceedings, those cases have already generated thousands of documented evidence and about the pattern of the Russian conduct. And when we return, for example, to the ECtHR judgments before the last year judgment on the merits in Ukraine and the Netherlands case, we had the admissibility judgment in 2023, where the court also in detail indicated and documented how the Russian Federation aggression developed from 2014, and the judgment and the evidence put in that judgment, they include quite detailed information and evidence from different sources that has been verified and accepted as admissible by the Strasbourg court. And those evidence include the common structures, the methods of control, the systematic nature of human rights violations, and the documents regarding the exercise of effective control and the responsibility of different entities. So we have all those facts and all those evidence documented in the proceedings before the different international judicial bodies, and also documented within the relevant domestic investigations, also by different monitoring missions in their all together they establish the facts that that are directly relevant for the work of the future special tribunal in this process to prove the crime of aggression. Another point is, and I think it will be much more difficult. It is a harder problem. It's to bring the defendants to the courtroom, and it's also to enforce the future judgments. We understand that the Putin and Russian management will not going to present them voluntarily to any tribunal. We see this situation before the current judicial bodies, we understand that at least for now the institution is building that will operate in absentia. That is a real limitation, but it's important to, in any case, it is important to have this legal record. What had happened, and a legal record of all these crimes and the crime of aggression that creates the basis for the future accountability. Thank you.
Thank you so much, Marharyta, and thank you for pointing into the or already alluding into the possibility of the in absentia judgments. That will be the topic of, let's say, the next round of questions and the role of symbolic judgment. But staying still with this don't let the man off the hook theme, my question to Professor Adam Bodnar is, given that Judge Gnatovskyy already and so comprehensively explained the limits of the international criminal law and the international criminal court in terms of legitimacy and recognition, we know that the tribunal has been pursued by this core group of 40 countries, and Poland was always, I mean, from the beginning, a part of that core group of countries. So how did a political consensus within that core group shifted from UN to Council of Europe regional solution?
Okay, maybe this way. No, it's okay. I think it's quite interesting to look into this process of getting to this idea that to this treaty that we have right now, treaty on the Special Tribunal for the Crime of Aggression, because it was not that obvious from the very beginning. So if we are looking into this time frame, this 4 years period, we could see that there were different concepts being discussed, and I think that international community was not really very much certain which way to go. Because obviously, if it would be the global tribunal with the support of the UN, of course, it would have much more legitimacy, and it would be much easier to pursue those rules of customary international law and all those issues that Judge Gnatovskyy has mentioned. But then there were, I would say, different constraints. On the one hand, creating it with the support of the UN would require the consent of the Security Council, and then we know the position of Russia towards existence of that kind of a tribunal. But second, there is like a general hesitance not only of Russia but also other members of the Security Council towards any forms of accountability for war crimes. So there is one more reason. But also, and I think that was quite important, we should look into the regional context. For Europe, the Russian aggression towards Ukraine is the most important thing. I think there is, but if you ask somebody from Latin American countries, from Southeast Asia countries, from Africa, they don't perceive it as such a great or such a grave threat. So they started to ask the question, okay, why should we right now go into this direction when and why we are singling out this specific conflict? And I even remember one. I was participating in one session. It was organized by the BMW Foundation in Berlin, and we had a presence of people from different continents, including from different African states, and we started to have like among leaders a discussion about some methods of accountability. And I remember this like a very strong voice from African countries saying, come on, you know, there were so many conflicts and the international community didn't react to that extent. So why right now Ukraine should be supported to this extent? So we should remember about this in the context of this global possibility. So then there were discussions concerning creation of some kind of a hybrid tribunal, so that it would be more like Ukraine that is taking the effort, but with the support of international community in pursuing this accountability for the crime of aggression. But at the end of the day, the position has been agreed that it should be simply the court with the regional support of the Council of Europe. And please look that Council of Europe from the very beginning was quite active, not only in this discussion, but also in documentation, in creating register of damages, and in creation of this compensation commission. So Council of Europe had I would say, kind of a good track record in terms of being involved into this process. Also, the Reykjavik Declaration from May 2023 confirmed the involvement of the Council of Europe. But naturally, Council of Europe alone is, in my opinion, would not be enough. So that's why, and I remember it very well, that when the decision to sign the treaty has been made, it was extremely important that ministers, member states of the European Union agree on this, and also that there is a support of the European Commission, of the European External Action Service, of Kaja Kallas as the EU representative for foreign affairs. So it is, I would say, Council of Europe and Ukraine treaty, but with the great support of the European Union, and also with a possibility for other countries to be involved into this. So not only being regional, but I would say like going beyond borders. I would, if I can compare, a little bit like Venice Commission, okay, which is not just purely European enterprise. It has a much bigger dimension. But I think that I should add one more perspective to this. Please look into the position of the United States towards this issue. In the very beginning, United States obviously was not going to be part of it, but it was kind of supporting the creation of the tribunal, and there were, under the Biden administration, there were some special prosecutors from the Department of Justice that were delegated. There were diplomats that supported those accountability efforts. But then I would say what we could with the Trump with the second Trump administration, we can see the questioning, challenging the issue of international accountability, and it is not just questioning; it is attacking the ICC. It is these are sanctions against the ICC judges, against prosecutors, staff of the ICC. Just 1 week ago, I participated in the session before the Legal Affairs Committee of the Parliamentary Assembly of the Council of Europe, and we discussed the upcoming report by the Parliamentary Assembly about different sanctions. And it was, quite a difficult situation that, on the one hand, we discussed arrest warrants and convictions regarding judges of the ICC that have been issued by Moscow City Court, including against Polish judge Piotr Hofmański. And then, for a really long time, we discussed all different sanctions against the ICC members. Please look also that United States recently, by executive order, decided to withdraw from ICPA, which is the International Center for Documentation of the Crime of Aggression, the center that is created under the umbrella or in cooperation with the Eurojust in The Hague, and the center which has an extremely important role in this whole environment, because it is kind of a preparation of the case for the special tribunal. So one may name it that they are acting in this pre-investigative phase. So they document everything in cooperation with prosecutors from different other countries, including Poland, in order to have a ready case when the special tribunal starts its action. And the United States openly, by the executive order, decided to withdraw from this mechanism. So in my opinion, we should be, to be honest, I must say that we should appreciate that this tribunal has been established as the regional enterprise with this, let's say, global backing, because because with this unpredictable position of the US administration, maybe we would be still in a position of negotiating, discussing, and nothing being agreed. And right now, we have the way forward. Thank you.
Thank you so much, and thank you so much for bringing the big elephant in the room, which is, I think, the US positions in the international rule-based order at the moment. But following on from all those complexities around ICC, around the special tribunals being a regional body with more global backing, I know, Tsvetelina, that you also, within the broader framework of accountability, pursued with the Reckoning project the universal, the option of the universal jurisdiction. Would you like to comment on that?
Thank you. And Adam, if I may, this is a very good point to make as a preface to everything that I'm going to be saying. That's not working now?
It is.
Okay. That all of this discussion about criminal justice is happening at the background, a very fraught geopolitical, and very unfortunate geopolitical climate. So when it comes to that idea of not letting the main man off the hook, of course the main man or the main woman will be different for different types of crimes. So it will be one thing to speak about the category of the main person in relation to aggression. It will be different when it comes to other international crimes. And the universal jurisdiction complaints that we filed with the Reckoning project had to do with torture as a war crime and a crime against humanity. And there the perpetrators were low and mid-level perpetrators. Now, it was the case of a very young Ukrainian man who was detained from occupied Ukrainian territory. He was tortured, he was held in inhumane conditions, and upon his release, he was keen to pursue accountability. And then the question was where to do that and how to support him in that process. And we filed a universal jurisdiction complaint in the federal courts of Buenos Aires in Argentina. it might seem a little bit odd that you would actually take this complaint more than 8,000 miles away from Ukraine, but I'll say why it actually made sense to pursue this specifically in Argentina. But maybe to start with this question about the effectiveness of universal jurisdiction as a whole, you already addressed one of the main challenges, not only to universal jurisdiction, but also to the exercise of territorial or nationality or any type of jurisdiction by domestic courts, but also international courts, and it's actually getting the relevant persons to the courtroom. So this is not a universal jurisdiction specific issue, but of course if the expectation of this type of accountability is to actually have the person in the courtroom and then to get the conviction and then to get that person to serve prison time, maybe it's not going to be an effective tool. So it really depends on what we think it has to be effective for. But I think that universal jurisdiction can be very effective for a number of reasons. One of them is to show that this is not just a one-country issue. It's not only about those who are most directly impacted by specific crimes, but it is truly an international community effort to fight impunity. So I think that actually using and resorting to universal jurisdiction can strengthen the fact that we're talking about something which is, after all, the duty of the international community to combat. The second point is that universal jurisdiction can be quite helpful in building bridges of empathy and understanding between different persons from different states, and this was also our experience, that this was a very good way to actually humanize what is happening in Ukraine by bringing one specific person to Argentina to meet the relevant stakeholders. Now, a third point was that this is also a way to combat disinformation in many countries, because the information umbrella of Russia spreads very wide, unfortunately. So by bringing these complaints, this is a way to also bring the story and to provide a record of truth about what is actually unfolding in Ukraine. And then a final one is that for many of these people who have gone through the suffering of international crimes, this is a way to reclaim their own agency. They have been treated as an object of power, but by filing this, and also filing this in another state, engaging with a different community, this is really a way to say that I have suffered, but I now have the courage to make this act of resistance. Now, for Argentina specifically, the question that we very often get is why Argentina? And there's a number of reasons that we can point out. The first one is the gateway criterion, that is, there is a legal basis to do so, because they have established universal jurisdiction in their very constitution, and it is the consistent practice of their courts that they accept universal jurisdiction. That is to say, there doesn't need to be a nexus to Argentina. So even for international crimes that have been committed elsewhere by perpetrators of a different nationality and victims of a different nationality, they can still review those cases. The second one is that, unfortunately, Argentina has its own experience of international crimes coming out of the military dictatorship, and they had experience of the types of crimes that we were bringing forward, specifically when it comes to torture through electrocution. And we didn't want to just parachute this complaint in, and this comes back to this point that you raised, that there is very often a sense of why always about Ukraine, what about all these other crimes that haven't been acknowledged. But here what we wanted to do is to really make sure that we learn from the Argentinian experience, and the complaint was very much based on their jurisprudence and on how they approached the question of torture. Another one was that propaganda by Russia was quite prominent in Argentina, even in some circles that would be quite like-minded in the human rights lawyers. So it was a very good way to actually talk about this more and to have a number of events where we had that marriage of law and journalism to make sure that the story gets across to a wider audience. And finally, for the complainant himself, I think it really mattered to him that he met persons who had suffered torture from the military dictatorship. They were able to talk about their own experiences. He met human rights lawyers. He met a number of people from the Argentinian legal community. And I think that this made him feel seen and recognized by persons who are so far away from home, but that they could still see that suffering that he went through, and could also recognize his courage in bringing that complaint forward.
Thank you so much, Tsvetelina, for talking so passionately and also with such great sensitivity about that case in the context of universal jurisdiction. Moving to the third round of questions, and it's something that Marharyta already alluded to in her response, is that the Article 28 of the Statute of the Special Tribunal allows trials in absentia. And my question to Judge Gnatovskyy is that while this is a controversial route, the statute then includes a provision of a right to retrial in case that person is later captured. So what are your views on, as a judge, on that proposed mechanism?
Yes, thank you very much. And this answer will be much shorter than my previous answers, I promise. But it's a great question. I think that it is a controversial issue, but I've always had the view, very strong view actually, that the possibility of trials in absentia was a necessity for the project of the Special Tribunal. We had this discussion from the very outset with Philippe Sands and others. And there's clearly, of course, the common law tradition that is against, in principle, such trials. And this has a lot to do, of course, with the adversarial nature of the criminal proceedings. And there's the European continental view, which allows for this option. The fact that the Special Tribunal is now being set up under the auspices of the Council of Europe also links it quite tightly to the case law of the European Court of Human Rights. And in the case law of the European Court of Human Rights, the approach to in absentia trials is very well established. And essentially, they are possible, but the possibility for retrial must be ensured. And I think in that respect, the statute of the Special Tribunal is faithful to the principles that already govern such matters in Europe. So I think in that respect, I don't see a particular problem. Let's be honest. The question of, and that relates to in absentia, but also to the earlier question of immunities, the chances of the main perpetrators or the main suspects, let's say, to appear before the tribunal in person, these are, they are basically, well, we can all estimate them ourselves, but essentially this depends on the factual circumstances which are beyond our control. And you cannot win a war in the courtroom. I mean, the real war in the courtroom. But you can be ready, and you should be ready. And also the effects of in absentia trials that can already be ensured before the war is over, they shouldn't be underestimated.
Thank you so much. Following on from that, my question to Marharyta, if you could tell us the Ukrainian state, I mean, in your capacity as the agent before the European Court of Human Rights, would the priority be to have the in absentia trials as a way of expressive justice, or does it also risk the justice becoming much more symbolic than real for the victims?
Thank you for this question. I can say that from our side, from Ukraine side, the best option would be to have not the trial in absentia, but to have the suspect to be brought to to real responsibility. But I wanted to push back gently the framing, the symbolic punishment, because it from my point of view, it somehow underestimates what the justice is. When we are speaking about the trials in absentia and how we take this idea for on practice, we need first of all to to pay attention that Ukraine is pursuing accountability through multiple parallel tracks at the same time. So we have the ICC, we also have the ICJ, we have the ECtHR interstate applications and both individual applications. We have the register of damage. Now we will have the special tribunal. We also should be realistic. Then none of these mechanisms, now this avenue will individually produce the moment when the management of the Russian Federation is physically brought to justice in the at least in the nearest future. But collectively, altogether, all those mechanisms they build quite important things. First of all they because given such different tracks, we have the authoritative legal record that this was a crime. We also have this legal record regarding those who committed those crimes. We have also legally recorded the victims and the relevant harm that they that they have in result of that crime. The convention in absentia matters for several reasons. First of all, for the victims, because they will have that judicial decision was recorded that will declare what had happened with them, and it was not so-called special military operation, but the supreme international crime, and it's also important for them. It's now we can say that this about the such judgment, future judgment will have that will have more moral weight. But I can say from my work in interstate cases against the Russian Federation, we also work directly with the victims of the Russian aggression, and most of them told us that the important part, the important thing for them was that their history, their story about those violations, about those crimes committed against them by different Russian military or by so-called forces of DPR or LPR that are under full control of the Russian Federation, that those crimes were committed against them, and that will be documented not only in Ukraine at domestic level, but also on the international level, and that their stories of the crimes against them that will be heard on international level. So this moral side of this proceedings, even in absentia, it's important for the victims. Another matter is that such judgments, the future judgments, they will create the legal basis for the, for example, asset seizure, for the future extradition request, for the travel restrictions, for the for sanctions, for the political and diplomatic pressure. Also, it also has effect from the political side because when we have some judgment, even in absentia, regarding the management of the Russian Federation for crime of aggression, those individuals then they already in the international system they will be have the status of the war criminal. It's also important. This like for now as I started for us, for Ukraine, it would be better to have all the management and the individuals, all those who committed crimes against Ukrainians, to have them in the courtroom and to bring them to the responsibility. But we need to understand the reality that in the nearest future we do not have this option, but still the judgment in absentia, they still have the practical importance both for the victims. Thank you.
Thank you so much for presenting the perspective from of the let's say prosecution side, and now moving to the diplomatic aspect or international diplomatic aspect of in absentia trials. My question to Adam Bodnar here: does the prospect of in absentia trials help or hinder the diplomatic effort to arrest those individuals in third countries? I mean, you know, there is we all know that there is an indictment against Putin, and yet in his visit to Tajikistan in October, nothing happened, even though Tajikistan is party to the ICC. So if a leader knows that there is a standing indictment for aggression, does that make them more likely to stay in power forever?
I think that it is not the issue they take into account, really. Okay, the question of potential accountability. I think all Russian leaders will stay in power as long as they will be able, and as long as there is no, I don't know, some internal revolution, coup d'état, whatever, that is changing the power, and then it makes that it may lead towards some kind of a transfiguration of international relations, and also in the context of accountability. I think that in the context of, because I would like to add one more thing, or maybe two things to what has been already said regarding the trials in absentia, because of course it is controversial. Okay, it is, as Judge said, it is very much not in line with the traditional thinking about fair trial. But I think it is important that we have this important judgment by the European Court of Human Rights, Sejdovic against Italy, which is giving a framework, a legal framework, how we can structure those trials in absentia. And we should remember that those people should be properly informed, and I can imagine that there will be some kind of a announcement, global announcement about starting the trial. But I think important aspect of it is that they should be defended before the special tribunal. So whatever case is, it is not about creating some kind of a kangaroo procedure that which is going forward, but those defense counsels nominated by the tribunal from the special list, they would simply do their proper legal job, so using their legal skills and ethics in order to represent arguments on behalf of those who are standing the trial, although they are not present. And in my opinion, it is an important guarantee, and it should be taken into account. Not only this right to retrial if the person appears, but also that this person is not, although being absent in proceedings, is properly represented. And I think that in this context, because one may think, one may ask a question, okay, but maybe it should be like this, you know, Damocles sword that is hanging around, that maybe we should resign from this in absentia trial and just wait for this reconfiguration of in international politics, and maybe, you know, in 10 years, 15 years, you know, there will be somebody who is on the hook. But can we wait? You know, let's look into the case of Slobodan Milošević. As far as I remember, it was 25 years, yeah, after which we had a final verdict in this case. And here we have a situation when you have this whole documentation being already collected. You have this evidence which is collected and prepared by Eurojust and ICPA in accordance with ICC standards. You have victims that have submitted their confessions and their testimonies. You have the international cooperation of prosecutors. You have a lot of digital evidence here. So simply you have to move forward with it. You have to move from the moment when you are just collecting evidence to the moment when you are doing like a proper trial, using all those guarantees that are possible in this specific situation. But, and I think it was extremely important what Marharyta said, which is giving the voice to victims. You know, if we look into the story of the ECtHR, into the Special Tribunal for Rwanda, into special courts for Sierra Leone, Lebanon, and so on, we see that these victims, and of course ICC, we see that this victims' participation is equally important as the accountability at the end. That the fact that they may speak, that they are heard, and not only that they personally are heard, but that the whole nation is watching. That people could see what is happening in this court. And so if this court is created and starts to operate, I think it would be tremendously important that this participation of victims giving testimonies is giving like this chance of bringing justice, even when those perpetrators are not yet present in the courtroom, but at least they are properly, in accordance with standards, represented.
Thank you so much for bringing the very important issue and perspective of representation. That, you know, we are not talking that even if the in absentia procedure is implemented, there would be a full representation of the defendants. Before I open the panel or to the questions from the audience, I have just one last question to all of the panel, which is, if by the time the tribunal is operational in 2026, hopefully in 2026, what is the one thing you hope it has achieved, or it would have achieved, to make a world a safer place than it was on the morning of the 24th of February, 2022? Judge Gnatovskyy.
Thank you very much. That's probably the most difficult question. But I think what is of paramount importance, and I might not really sound very legalistic here, but I think the actual reason for this project to exist, the paramount consideration, in addition to all the valid points that have been mentioned today and that very much feature in the discussion since the very outset, is that the very existence of the tribunal, just the very existence, not necessarily even the verdicts, the judgments, but the very existence is a safeguard against banalizing what has happened, against basically forgetting what is happening, against imposing a version of history that suits the aggressor, that allows them to get away with it. If you, I mean, I'm sure all of you are to different extent, but still all of you are aware of the various negotiations which are happening now, and the role, the very peculiar role that the current US administration is playing in that. One of the ideas is essentially to let the aggressor get away with it. And if the tribunal is there, if it is functional, and I hope we have passed already the critical point where its creation is already the fait accompli, that is an excellent, I would say, vaccination against this evil. Because allowing them to talk this over, allowing them to basically let everything drown in the mist, of their propaganda of whataboutism and things like this, would be the most terrible service we can do for the world and for the future of the world. And of course, I might sound biased as a Ukrainian, but honestly, they have, historically, they have gotten away with so many instances of aggression, so many instances of terrible atrocity crimes. And we simply cannot allow this happen this time around. Thank you.
I have intelligence that Oleksandra Matviichuk is now ready to join us. So I'll give Advit a little time to join her in. And while we are waiting for her, Tsvetelina, would you like to join with your hopes for the tribunals making the world a better place?
Yeah, of course. Can you hear me okay? Yes. Good. I would perfectly agree with the point that this is just a way to ensure that there is no complete sense of impunity for what was caused. Thank you. It's a way of avoiding this sense of complete impunity for what has been done to Ukraine and to the Ukrainian people. And I think that even though, as Marharyta mentioned, there is a full ecosystem of accountability actors who are operating. We have human rights bodies, we have the International Criminal Court, we have domestic courts. There is still something quite distinctive about having a tribunal for aggression. And my impression from talking to victims of crimes in Ukraine has been that very often the crimes and the language that we're using does not fully capture the wrong that they feel. So, for example, torture might not fully capture it, rape might not fully capture it, but sometimes what they say is that what was taken away from them was their very way of living. And I think that this is where aggression comes in. It was because of the aggression that they're not able to live the way in which they lived. And I think that for this purpose, this tribunal is going to serve a very important function for this entire community of victims who are really hoping for some true measure of accountability.
Thank you so much. In the meantime, that I can see that Oleksandra is with us. Welcome. It's a great pleasure of us to have you here amidst your super busy schedule. Oleksandra, I know you've recently written quite critically about the slow coming together of the tribunal. Do you see that as a failure of diplomacy or maybe a symptom of a broader political problem?
Thank you very much for providing me a floor and for this unique opportunity to contribute to the discussion. Before I answer this question, let me tell you my personal story. 4 years ago, when Russia started large-scale war, I was in Kyiv. I refused to evacuate, and with a part of my team, we continued our work on the ground. So, since this time, I start to ask to myself a very simple question. Who will provide justice to all people affected by this war? Because we're faced with enormous amount of crimes. And being a lawyer, I understood that there is a accountability gap which is very visible because there is no international court which can prosecute Putin and top political leadership and high military command of the Russian state for the crime of aggression. But all atrocities that we are documenting, it's result of their leadership decision to break the peace and to start the bloody war. So this is very logical for us, being a human rights lawyers, to be involved in this international campaign of promoting of special tribunal and aggression. And last year in June, Council of Europe made a significant step forward to establish law and justice, and the official process of creation of special tribunal on aggression has launched. But almost a year passed since the June last year, and only several countries joined. And I came to this discussion just from the meeting with Netherlands parliamentarians, and we discussed what's the problem, why other countries are still waiting. And this is the basis of my critique, because it's not Putin who prevent the creation of special tribunal on aggression. It's probably lack of leadership. It's probably lack of historical responsibility.
From your perspective as a human rights lawyer and a human rights monitor, what are the real costs of the tribunal's slow operationalization, particularly from the perspective of the victims? I mean, here in the discussion, we touched upon this, and I just wanted to apologize to the audience for taking this slightly different scenario. But now that we have Oleksandra with us, I thought it would be just to direct a few questions at her. Thank you, Oleksandra.
All this hell which we face in Ukraine is the result of total impunity that Russia enjoyed for decades. Russian troops committed horrible crimes in Chechnya, in Moldova, in Georgia, in Mali, in Libya, in Syria, in other countries of the world. They have never been punished. They believe they can do whatever they want. We must break the circle of impunity, not just for people in Ukraine, but in order to prevent a next Russian attack to the next nation. But what we have for current moment? Last year, President Trump started so-called peace negotiations with Russia. And we all remember that in first 28-point plan, we see the point of total amnesty to Russian war crimes. We are not naive. We know that justice is not priority for United States administration, and it's very difficult even to imagine that Russia will sign any kind of peace treaty with some concrete accountability issues in this treaty. So our task is to make justice as independent parallel track. What do I mean? International Criminal Court doesn't care what will be written in this 28 points plan. International Criminal Court will not stop its investigation, will not withdraw arrest warrants. So while we still have this window of opportunity, we have to establish several additional international accountability mechanisms like special tribunal on aggression, like international registry of damage. We have to confiscate Russian frozen assets because justice has financial side as well, and so on and so forth. Because we don't know how much time we have, how long we will have this window of opportunity. We must do it now. And what I see when I do my advocacy work, visiting different countries, speak with presidents, with prime ministers, with governments, with members of the parliament, I see that a lot of people still look to the world through the lens of the Nuremberg trial, when Nazi war criminals were tried only after Nazi regime had collapsed. And it was victorious court, and that is why established like a general perception that justice is privilege to winners. But justice is not privilege. Justice is a basic human right. And we live in new century. We must move further. We have our own historical task to make justice independent on the fact how and when the war will end. We cannot wait. We must establish special tribunal now.
Thank you so much, Oleksandra. I really think it's a very powerful metaphor. We usually say that it's the history that is written by winners, and you made this connection saying that, you know, justice, if we look at Nuremberg trial as the benchmark, also was the attribute of winners, and that is not right. That shouldn't be. So in that context, beyond the states and institutions, what is the role you see for local civil society and grassroots activists like the Center for Civil Liberties in actually pushing that tribunal forward?
Civil society in Ukraine always play a crucial role in all positive changes and democratic transition of our country. But without help of civil institutions, civil actors, NGOs, academia, human rights group, and political parties from other countries of the world, we will not succeed in this ambitious goal to deliver justice. And that is why I think that we have to unite our efforts, and not just for people in Ukraine. Let me return to the state on the ground. Despite all these peace talks, it's obvious that Putin doesn't want peace. Putin wants to achieve his goal. Putin started large-scale war not because he wanted to occupy just another piece of Ukrainian land. He lost hundreds of thousands of Russian soldiers, not just to occupy Avdiivka or Bakhmut, which majority of Russians couldn't find on the map. He's not mad, he's very practical. He started large-scale war because he wanted to occupy and destroy the whole Ukraine and move further. He sees Ukraine as a bridge to Europe. His logic is historical. He dreams about his legacy. He wants to forcibly restore Russian Empire. And that is why people in other European countries, they are safe only because Ukrainians are still resistant to Russian aggression. But resistance is not just military term. It also needs decisive legal actions. And what I understood that very often people look to the justice from the very narrow perspective. They understand justice as something which had impact to the past, because you persecuted someone for something which had already been done, or they see justice as something that has impact to the future, because you send this powerful message that if you will be committing the following things, the similar things, you will be also persecuted. But justice have a huge impact to present. What do I mean? A year ago, our Russian colleagues from Memorial analyzed Russian tactics in Chechnya, in Syria, in Ukraine. They told, this is the same war crime playbook, the chain of wars, chain of crimes, and chain of impunity. So if we start decisive legal actions, even if part of Russians start to be doubt that probably this time they will not avoid responsibility, that they will be prosecuted for their own decisions and for their own actions. Even if part of Russians start to have such doubt, this doubt will be converted in chilling effect of brutality of human rights violations. And because we speak about present, and our present is ongoing war, which is very bloody, just with decisive legal actions, we can save thousands, thousands, and thousands of lives.
Thank you so much for, again, providing a very current perspective on the transitional justice, that it cannot wait, and bringing the justice very much as a matter of presence. With this message, I wanted to open the floor to questions from the audience. I will use the help of Advit, if that's okay. If you could raise your hand and just briefly introduce yourself and say to whom that question is, it would be great.
Brilliant. Thanks so much. Is that, oh, perfect, yeah. So thank you all very much for the talk. Generally, it's been absolutely informative. I do have a quick question, sort of leading on from Oleksandra's point, because it was a really important point to bring up about this trial and actually ensuring that there is actual justice and that impunity is not the actual outcome. So how do you ensure that this tribunal does guarantee accountability beyond just essentially words or written statements? Thank you.
Judge Gnatovskyy, do you want to take this?
Thank you very much. Great question. I think the best way to guarantee it is a military one, coupled with relevant political decisions, economic policies, and so forth. But it's essentially, it boils down to political will and to the military power. Because, well, it's, and that is the stumbling point. Because, but then once again, I think the way you formulated your question presupposes that there's little value in simply a legal document, let's say a judgment, and I think, well, from what I gather from our panel, we all beg to disagree, because we think that this is already a significant achievement. But of course, to make this world happy and a better place, well, Ukrainians would say more weapons for Ukraine. Well, as simple as that. Sorry.
Oleksandra?
Frankly speaking, I don't understand the sense of questions. The quality of sound wasn't very good. Can you just repeat it?
I'm terribly sorry. If I understood correctly, the question very much referred to your call for justice and the justice now, and how to ensure that the special tribunal for Ukraine, for the crime of aggression against Ukraine, its judgments are actually enforceable, and we don't see the cycle of impunity continuing.
We have to create it, because now we are stuck. As I mentioned before, just 5 countries joined. And we have also a lot of unsolved technical problems. And for example, the budget of this court, which still not as clear who will cover it. How much time it will be needed to create a team of the court. What we have from the public signals that Netherlands expected to spend 3 years just to create and to hire the team of the court. And I know that the Tribunal on former Yugoslavia, it issued a first verdict in a year of decision of its creation. So the question is how to make this process move more quicker. Because while we have this window of opportunity, we have to use it. We don't know what will be next year and the year after the next year, because the political situation are changing in different countries. And I think it's very important for not just for Ukrainians to establish this tribunal as quickly as possible. There is something more than that. If we want to prevent wars in the future, we have to punish states and their leaders who start such wars in present.
Thank you so much. Tsvetelina?
Thank you. The panel does agree that even without the enforcement, there is still a value in having this process, but I do think that there is also a concern about expectations not being met, that once there is, for example, a judgment, there is going to be a question, well, what next? Is it just going to remain on paper? Yeah. And this is not an issue which is only for the special tribunal. I think this is a more general issue in relation to international criminal justice. So I would say that what states need to do is to ensure that they're using all the possible mechanisms to implement responsibility for international violations more generally. And this is something that can be done through countermeasures, for example. Many states are already enacting sanctions in relation to Russia itself, but also to specific individuals and entities, but more can be done on that front. And for example, when we're talking about the universal jurisdiction complaint, one part of our consideration was that if there is an arrest warrant which is being issued for specific persons, this is also going to be a cost for them because it will limit their movement in space. So I think that these are limited but still ways of thinking about some measure of making that bite to the specific perpetrators beyond just having the historical record, which is still very important, but to move one step further.
I wanted now pass the mic to Adam Bodnar to also look at, answer to that question from the perspective of a lawyer, from the perspective of a former Minister of Justice, of the actual ending the circle of impunity. But also, Adam, I realized I cut you off when it was your turn to answer the question, yes, what would make the tribunal a better place? So feel free to address both of those.
Thank you. I would like to add to our conversation one specific issue, which is the crisis of multilateralism and I would say this traditional way of forming international relations and supporting the strength of international law. I think we have mentioned that anything that is in the statute concerning the Special Tribunal for the Crime of Aggression has been prepared after a very careful reflection, and according to some commentators, it is even quite conservative in terms of implementing some of the principles and putting them on paper. Regarding immunities, this very strong connection between the regulation of the crime of aggression in the national law of Ukraine and putting it into the statute of the tribunal, as well as, for example, we've mentioned this in absentia trials and strong attachment to the jurisprudence of the European Court of Human Rights. So why I mention this? Because maybe the way how the tribunal has been formed and the way how those enlarged partial agreements are right now signed, ratified, is a little bit like a response to the crisis that we are having globally. So if we do it, let's say, properly, it might be a little bit as not only as a signal that Europe respects those basic tenets of international law, that Europe has support of some other like-minded countries, and I refer a little bit to the Prime Minister Kearney speech at Davos, and that basically that is the only way for the world to go forward, irrespectively. And of course, the cause is extremely important here, which is fighting with immunity. And you know, whenever I have heard those different statements from American administration against the ICC and against any forms of criminal accountability, I started to think that maybe, you know, our European approach towards those issues is becoming something like the European identity thing. That here on this continent, you know, we cannot do it otherwise. And I think Oleksandra made it really, put it nicely, that that irrespectively of those peace talks, you know, if the justice is going forward with the use of universal jurisdiction, with the use of ICC, with the use of the Special Tribunal for the Crime of Aggression, then it may be a little bit beyond like the political daily perspective. I think your question concerning this accountability, I think, you know, naming and shaming and putting something on paper in a very proper judicial way makes a difference. It is important to victims, it is important to the whole world, but from a practical point of view, I can imagine that, it was mentioned already, that any travel, any cooperation between Russia and countries that are also part of international community would be much more difficult after that kind of a judgment. And here I count on this, and I also count on sometimes, you know, unpredictable track of history. look at Duterte. I think if somebody would ask a couple of years ago whether he would go unpunished, nobody would have even any thought about it. Right now, he's standing trial before the ICC. So different things may happen, and it is better to have the infrastructure for good times to come. Thank you.
I'm ready to take another question from the audience. Yes, the gentleman over there.
Thank you very much to everyone. My name is George Perushin. I'm a recent graduate of the university, studied philosophy. I'd like to ask a question related to the creation of the tribunal. So it has been mentioned that 5 countries joined the initiative, and until now the tribunal hasn't been created. Are we aware of any kind of international lobbying against it? Because I'd mentioned that some countries would be against it because it might create a precedent for them, like that would be in a negative, in a detrimental way for them. Yeah, that's the question I have. Thank you. And it might be addressed to anyone who is most, qualified to answer it.
Thank you. I will start then with Oleksandra, but I think it's the same issue with the sound, so let me repeat the question. The reason why I'm starting with you is because this is a fact that you raised in your initial critique of the tribunal, that it's very slow in putting itself together, that only 5 countries backed it now officially and joined it. Are you aware of any international lobby against the creation of the tribunal?
I think that one of the main issues is this very widespread impression that justice is contradiction to peace, which is not the case, frankly speaking. If people look to the situation from the short-term perspective, they can see the situation like this, that justice in contradiction to peace. But we have to look to situation from the long-term perspective. And through the long-term perspective, justice is precondition to peace, especially when we speak about Russia, that for decades used the war as a tool how to achieve its geopolitical interests, and for decades uses war crimes as the methods how to win the war. But we live in non-ideal world. There is law, there is politics, and there is gap. And now our main task is with the joint efforts to decrease this gap and to help to establish a special tribunal on aggression as quickly as possible. And I think that it needs, plus to this long-term perspective vision, also some human qualities as courage. Because these dramatic times test us for true leadership, for true responsibility, for true courage. You can't take just pause. You need to take a stance, position, and stance and position means actions. And probably some leadership think, let's wait how everything will finish. Probably in future we will have to return to business as usual with Russia. But I'm sorry to say that it's not possible, because the previous world collapsed. Change is a new normal. And the real battle is going on, how the new world order will look like. And do we have in this new world order the place for human dignity? Do we have in this new world order the place for freedom? And do we have in this new world order the place for justice?
Thank you so much, Oleksandra. I saw Marharyta nodding in response, particularly when you raised the points that we need courage. We need courage among international leaders to put this tribunal to practice. Would you like to comment on that, Marharyta?
Thank you. First of all, I fully support Oleksandra in this regard, and I also fully agree that the international community, the leadership of the states, they really need to demonstrate this courage. I can I also agree with this because from my own experience, I remember that even after the full-scale invasion in 2022, a lot of diplomats and representatives of different states, those who supported Ukraine, not only after the full-scale invasion, but even before, from 2014, at some point they were afraid to say that to use the word war, but they tried to use the word conflict, right? Conflict in Ukraine. They use those words. They were afraid directly to say the Russian aggression, the Russian war. So now the situation changed, but even in such, I must say, small things, like people, the management, the leadership of the states, they need to demonstrate that courage. I fully support that. Now we are living in the period when everything is changing, when the international law, international policy, international relations, they are in the process of changing, of developing, of transformation, and from everyone, not only from Ukraine, but from everyone in this process. Everyone should contribute to this process, because now we are Ukraine not fighting for its own future. We are in fact now fighting for safer world. I understand it may be quite general word, but it's really how the things are going now. Thank you.
Thank you so much. I can tell that this theme of change in view of the crisis of the rule-based international order keeps coming in our conversations. And I wanted to ask Adam, because he particularly mentioned that this also requires courage and a stance, and whether that can be part of the European identity.
I think that at the level of the European Union and the Council of Europe, we could see this courage and this growing trust. You know, if you look, for example, into different statements by Ursula von der Leyen, being the part of the State of the Union, you could see her position. I was really impressed when she quoted work by Victoria Amelina, and you know, when Victoria Amelina has been presented as this person who should become for us a symbol. The problem, I think, is at the level of not organizations but individual states. Because those states have different interests, and those interests are in collision, and sometimes moreover, we have some states that are quite openly promoting a completely alternative vision of the world. You know, just quite, you know, a few weeks ago, we had a situation when Hungary has arrested people who are legally transporting money from Austria to Ukraine as a part of the traditional, you know, banking transaction. You know, I cannot even find words to name that kind of incident on the part of Hungarian authorities. So that is what I'm afraid, that there might be, you know, countries that are openly collaborating with aggressor. There might be countries that are simply afraid of being intertwined. There might be countries that are creating too strong alliances with those who are opposing, in general, any forms of international accountability. That on the one hand, we might have a really proper position of international organizations, but then, you know, the real effect ends up with different tensions and dilemmas at the level of individual states. But we should do simply our best, and I think here the role of the civil society is important, the role of scholars, intellectuals, academia, to all the time to repeat and all the time to remind us, you know, what we are fighting about, and that this 4 years period should not immunize us from further action, but quite otherwise we should go forward with creating those frames for accountability.
Thank you so much. I'm ready to take another. Okay, so we have 2 questions. So the lady at the back, and then the. Oh, sorry, 3 questions. Okay, how about we take them all together?
Hello, thank you. My name's Talia. I'm just finishing up a DPhil here. This is a question for Tsvetelina about universal jurisdiction. This is fascinating, by the way. I hadn't thought about the secondary benefits of it. Very interesting. I was wondering, with the possibility of there being so many potential cases that could be tried for these sort of mid-level mid-level in terms of hierarchy, right? And understanding that the capacity of a court like Argentina would be limited, what would be a selection process for which of these cases would be best suited for universal jurisdiction? Thank you so much.
Yeah, excellent question. And the question of capacity is one which is very much at the forefront of these discussions. But I would say that, of course, the International Criminal Court does have its own guidelines in relation to selection prioritization for the investigation of cases. And what it does take into account is the gravity of a specific crime and also the responsibility of the perpetrator or the alleged perpetrator, where we're talking not only about the jure hierarchy, but more generally all the factual circumstances that would establish the responsibility of that person. Now, I would say that it might be that precisely national jurisdictions are very apt to look at questions that pertain to lower and mid-level perpetrators. And I wouldn't overemphasize that question about capacity, especially when it comes to national courts that have a specific expertise in certain types of crimes. Of course, there is going to be some kind of division of labor between the territorial state. Here we have a unique situation in which the territorial state is one that is actively investigating and prosecuting, and then maybe different types of cases that relate to different types of crimes that can be spread out in different states that have a specific expertise in a specific type of issue. It might also be that different cases will be combined if we're talking about specific patterns and incidents with similar perpetrators, similar regions. So there are ways around it, but I think that this is usually a fairly easy cop-out to say that nothing has to be done because it's going to be a capacity issue. I think there are many ways in which that can be overcome.
Thank you so much. My name is Yevhen. I'm a DPhil student here in Oxford. My question is about is related to what Oleksandra mentioned in the end about the collapse of the previous world system, and that question is sort of comes from what Judge Gnatovskyy mentioned at the beginning about how this whole system evolved since Nuremberg trial. So while the system is collapsing, all of the speakers are still referring to the principles that were established in post-Second World War order of human rights, where human rights were seen as the virtue toward which the human beings should strive. And so my question is, to which extent do you see this kind of challenge coming up to the entire concept of human rights as such as being a value? Precisely because the whole system and the Universal Declaration, inclusive, were created by the very same powers that were victorious in the in the Second World War, essentially. So, yeah, there is like this obvious challenge that is inherently present in the system, and still we don't seem to have better language to work with that. and also apply in practice. So how do you see, what are the possibilities to deal with this issue? And maybe it's partly would be the question to Oleksandra, but maybe also to other speakers who are touching on these different challenges. Thank you.
Thank you so much. Oleksandra, may I just check whether you heard the question? Fantastic.
Yes, I heard the question. Thank you for this. It's not easy to answer. I don't know how historians in future will call this historical period, but we happen to live in a very turbulent time when the world order that based on UN Charter and international law has collapsed. For the obvious reason, the system was created in past century to prevent wars and mass violence, but now just stalling and reproducing ritualistic movements because the world has rapidly changed, but the system has never been reformed, while even my smartphone has an expiration date. So, unfortunately, it's easy to predict that such fires, like wars, will emerge more and more often in different parts of the globe because the international wiring is faulty and sparkling everywhere. And this is Russian war of aggression against Ukraine will also have a huge impact on the new world order, because with this war, Putin attempts to convince that democracy, rule of law, human rights, freedom are fake values because they couldn't protect anyone during the war. Putin attempts to convince that country with a strong military potential and nuclear weapon can break international law and UN Charter, can dictate its rules to entire international community, and even forcibly change the international recognized borders. And if Putin succeeds, it will encourage other authoritarian leaders in different parts of the globe to do the same. Last year, we made a significant step back to past as a humankind. And let's be honest, this past wasn't great. This was a past which was based not on rule of law, but on will of strongest. And we know from the history that the world which is based on will of strongest is a very fragile world. It's always a world of wars and mass violence. But what is a vision of optimism in this situation? I'm a lawyer, and I'm documenting war crimes in this war that Russia has launched against Ukraine. I have no legal tools how to stop it. But I know that the war doesn't work, and I hope that it's temporary. Because it's not the first time in human history when people found themselves in such a situation. And our future is not just unclear, it's also not pre-written. This means that we still have a chance to fight for future which we want for us and for our own children. And we want to have this future with justice. We want to have this future with freedom. And we have to fight for it. And this is probably the main lesson learned from Ukrainians. While we are losing freedom in the world, and 80% of people in the globe live in non-free or partially free societies, and only 20% of people have a real right to vote for whom they want to vote and have a real right to say what they want to say, Ukraine demonstrated a trend opposite, because we are fighting for freedom with such enormous opposing power in different fields. It's not just military dimension, it's also legal dimension to restore the world order, to design it in a way that it has to be based on human rights and freedom. And what I can say, there is no guarantees, but we have a chance. And it's a huge luxury to have a chance. Because hope, it's not a confidence that everything will be fine. Hope, it's a deep understanding that all our efforts have a huge meaning.
Thank you so much, Oleksandra. And I cannot help but use probably once in a lifetime opportunity to ask the judge from the European Court of Human Rights what is the role and the future of human rights.
Yeah, thank you very much. I think it was a great question, and I think one thing we need to remember is that, quite rightly, I think you basically meant it in your question, I assume, is that when the Second World War ended, there were essentially 3 tracks on how to prevent its recurrence. There was the first is the prohibition on the use of force in international relations. Secondly, it's the accountability for those who committed crimes against peace, the crime of aggression, and the other supreme international crimes. And third, human rights. Because human rights as such, as a concept, is diametrically opposed to anyone who would like to achieve their so-called geopolitical goals, essentially by completely ignoring the value of an individual, of individual rights. And for them, people don't count. I mean, they don't really care how many soldiers they would lose today, because they know they still have more people to draw from, these new soldiers. And they, of course, they care even less how many people on the other side will die. And who's, even if it's not about death, if it's not about torture, as already mentioned today very, very, very rightly, I think it was Marharyta who said it, or maybe Oleksandra, I'm not sure now, is that it's also about millions of people whose lifestyle, whose lives were severely damaged. And the whole concept of human rights is precisely against that. And it's not accidental that somebody like Herr Schlauterpark, for example, was directly involved in all the 3 strands, in all the 3 sort of dimensions. And I do not completely agree with what has been just said, that the international order has collapsed. It has certainly reached the point of a major crisis. And this major crisis, it doesn't come from nowhere. It comes from, as an accumulation of many, many problems that existed before. Various violations of the prohibition on the use of force, various serious, large-scale human rights violations, and so forth. Now, of course, with Russia's aggression, it became very obvious, especially for the Ukrainians. It's basically, yes, it's sort of the end of our world. You know, for us, it is a matter of life and death. But more globally, I would say, this is a manifestation that indeed this world order has to be enhanced. But I think it's more spiral than it's simply, you know, just complete destruction. There should be a new iteration, and we should not lose human rights. We should not lose international criminal justice, and we should not lose the basics of civilized relations between states, including the prohibition on the use of force.
Thank you, and I think that will be the last question for today, the lady over there.
Thank you. I'm Harriet Moynihan from the Oxford Institute of Technology and Justice at the Blavatnik. And thank you very much to the panel for your valuable remarks. It was a question for Tsvetelina, who had mentioned the importance of universal jurisdiction as justice as an international community effort, and perhaps sort of around the world being able to use it as a tool to combat disinformation and to build empathy for the victims. And you mentioned the case in Argentina. I just wondered if you see any other jurisdictions which would be fruitful for cases, especially for Ukrainians, to have justice. And if you think there's generally a trend towards the strengthening of universal jurisdiction in this regard.
Thank you, Harriet. I would say that it's really a question about identifying the jurisdictions that have a legal basis that can be used. And European states have been very open about universal jurisdiction. In fact, many of the universal jurisdiction cases that we've seen have been precisely in European states. So, of course, there is this possibility of resorting to those who are the natural allies, if you'd like, to Ukraine, and who are already cooperating in relation to criminal justice with Ukraine. But I think that there is also a distinct benefit to thinking about states which are outside of the so-called global north. And this is precisely because of the point about disinformation. This is precisely because of the point of actually humanizing what is happening in Ukraine to other places that might not have seen that human face of the war. So in this sense, it's going to be a mapping exercise of seeing where these cases can be brought. And this is already something which has been done by a number of different organizations. The Clooney Foundation for Justice has a mapping tool for universal jurisdiction. So the effort is already underway. I think it's just a question of really making sure that we use every possibility to bring these cases to different places. And this plays into a more general point, which is that we very often tend to prioritize certain jurisdictions and to focus a lot, say, on the International Criminal Court, or to focus very much on specific crimes, but to feel like it's a defeat to say human rights violation as opposed to an international crime. I think that this is a much broader question about using every single possible accountability avenue to bring these stories of victims to the international community.
I think I'm going to use this microphone now to sort of end on the high note, particularly on the hope around the universal jurisdiction. Before I ask you all to join me in thanking our speakers in the traditional way with applause, I have one person whom I wanted to thank in particular, and that's Hanna Oliinyk, sitting here, who tirelessly over the 9 months in the past has organized the logistics, travel, made sure that this hybrid event works today. So in your applause, please also keep her in mind. So thank you so much. Thank you.
Hello. Yes. Well, yes, we had breakfast together today, but they're very kind. But they told me, they told me, you go to Tsvetelina. She's so wonderful. You're so lucky.
Yeah, we can stop the recording. I just wanted to kind of use
Thank you, pleasure. They were kind enough to join me for breakfast in the hotel today. Yes. No, I'm staying. Actually, I'll come for tomorrow's panel. Probably not for the entire one because I have a few other meetings here. No, I'm staying even until Saturday, so I'm taking my time a little bit here. Let us.